All right. Well, welcome everyone, and those who are watching the recording. I'm Tony Jackson. Most people know me as the Real Money Coach, and very happy that you are joining us tonight. I've been working closely with Noreen and your group, and we're very excited about what you guys have in store for you in terms of your investment. And we're looking forward to just bringing a team of professionals together. You guys have met Timothy Day a couple months ago. I've been sending out different emails as it relates to some of the financial matters and HELOCs and INLOCs and all those type of things, so that we can just kind of prepare ourselves for the wealth that is coming. And as part of that, we wanted to bring a expert, if you will, someone I have a lot of respect for, Miss Attorney Aimee Griffin, who is in the DMV area. Aimee has her own firm, the Aimee Griffin Law Firm, and she also, I believe it's Life and Legacy Counselors, and she'll tell you a little bit more about her background, and she's just going to share some information. I know many of you were looking for information about wills, trust, and even starting, possibly starting nonprofit foundations. Aimee is the best as they come, right? And so I told you, Noreen, that I would bring you the best, and we have the best tonight. Noreen, I don't know if you want to say something real quick to the group, and then I would just turn it over to Aimee and have her introduce herself and go through the information.
Thank you, Tony. I just want to thank everybody for coming on. I thank Aimee for making this time for us. And we're looking forward to some good information. Thank you for having us.
Great. Well, Aimee, I am going to spotlight you here, and you have the ability to share your screen and do all that you do. And so thank you again for making the time to come out, and we'll have some great long professional relationships as a result of this. So it's all on you, Aimee. Thank you.
Excellent, excellent. Thank you so much for inviting me, because I feel like it's part of my personal mission to share and educate. Actually, it is part of our business mission, actually. Vision is to strategically collaborate so that we can educate, and so that we know that it's important for us to hit many different industries so that we can collectively build. So I'm going to share my screen, and I always apologize in anticipation of my technological challenges, which we will undoubtedly experience. All right. But I always start off with a picture of the firm. Now, I do that for a couple of reasons, one of which is to talk about what I just think is a pretty powerful picture, number one. But I will say also that some of the faces are changed, but we are still, and there are more folks that are part of the team now, but we are still an all melanated group of women, and that's intentional. And we're very thoughtful about how do we impact our community, right? And so one of the reasons why I show this picture is that it is, when I started this practice, I was thoughtful about, I know that I'm a grown-up, and even as such, I know that I may not be here tomorrow. And so we operate as a team so that when something happens to me, I want everybody who's connected to have that big, ugly cry. I want the scream, the mourn, all of that stuff, but know that we have somebody else who is comfortable with you, you've met, had a relationship with. And so I speak to folks to say that if indeed you make sure, it is important to make sure that you know what the bench looks like in any trusted advisor, right? Make sure that they are not the lone wolf out there, and that they don't have a bench. The second thing I always want people to know is that our core values are first and foremost faith, excellence, relationship, service, and trustworthiness. It bothers me that we misspell first, but indeed, what we know is that everybody has a bias. And if we are clear about what we are, who we are, then we know that people can choose whom they're working with mindfulness. So that's another thing. So finding out what is the bias of the people with whom you are working so that you know and that you can plan accordingly in selection. Okay. And then there's that. Okay. Now, what is estate planning now? So for many people, we're not real thoughtful about the fact that for me, there's a whole totality of our assets, our values, the life that we're living, what helps dictate that. What's our charitable purpose? What is our succession plan? What are we doing with our life insurance? What do we want our kids to do and be, right? And how do we support that? All of that is factored into the conversation about what is estate planning. I say estate planning answers three questions. First and foremost, what happens when we die? And what we know is that people who, so many times that turns them off. They don't want to have a conversation with that. But indeed, the second question is, what happens if I'm unable to care for myself, if I don't die, but I'm just incapacitated? Now, I always think about the Diary of a Mad Black Woman. With that in mind, we know that we should be thoughtful about who's going to make decisions for us when we can't make them for ourselves, right? Pick the person that we want. We don't want the person who selects themselves. But thirdly, the powerful part about estate planning is identifying what's the legacy that I'm going to leave. We get to make that decision about what is the legacy that we want to leave. Now, I identify, give four great examples, right? There are hordes of them. First and foremost is Sonny Bono, who was married to Cher, for those of you who are old enough to remember Sonny and Cher, and I Got You Baby, the intellectual property that was a part of that relationship. And and so he died by skiing into a tree, right? And I will say to you that amazingly, as well-to-do as Cher is, she was there to try to receive what she could as the part of the intellectual property. However, Sonny was currently married to somebody else, and therefore Cher was without. But I will tell you the number of times that I've experienced managing estate administration where the spouse or estranged spouse or former spouse shows up. And so I'm very mindful of how do we make sure that the documents reflect truly what the plan is and who is who accordingly. As I know, again, I'm a Black person, and so many times we get married without getting married and get divorced without getting divorced. So I encourage people to be thinking about what is it we really want to make sure that we have everything in place with the plan. Aretha Franklin did not feel the need to connect with a professional. She took the time, the effort to create the ideal funeral, but she didn't feel necessary to engage a professional in doing her estate plan. So for many of you know that they found 3, not 1, not 2, but 3 handwritten wills that she had created. And it was such a chaotic mess that the woman that she identified, her niece, to serve as the executor, she resigned after a while, after all the litigation. Her estate ended up paying $8.1 million in taxes because she didn't feel compelled to have a financial professional involved. Steve McNair, I am not a sports fan, but I won't give this line up. What I do know is I found out he is was a Baltimore Ravens player. And he had an affair. He had a mistress. His mistress shot him and then shot herself, right? And then his wife became the executor of his estate and began to charge his mom for rent. And so she had to move. So there are 2 lessons at least to learn from this. First and foremost is don't have a mistress, right? That's what everybody should know. If you take nothing away from me, is don't have a mistress. Stay within your marriage or don't get married. And the second thing is, we know that a person scorned will take out things for the people that you love. So then have a plan in place so that you care for the people that you care for. And don't just take just assume that there's a default, right? So if we take the steps, if we take the plans, if we identify those folks that are in need and what it is we're allowing to go for their benefit, then we can take those steps and protect those people. And I say all the time that our family isn't just the legal or the biological relationships of the people that we love and that we care for, and that we can plan accordingly. And then the right-hand corner is Osceola McCarty. Now, not as wealthy compared to all the other people that are on the screen, but Osceola McCarty was a laundry woman, and she lived in southern Mississippi, and she was frugal. She was thoughtful. She dropped out of school in primary school to help her grandmother take care of her aunt. And so as a result, she was able to have, she didn't have any kids. So she was very mindful about how did she protect her assets. She didn't have an HVAC system. She had portable air conditioners in her house in Mississippi. So, that's a thing. But when she passed away, she had used her trusted advisors, counted on them. She had a financial advisor and she had an estate planning attorney. As a result, little becomes much. She's also a woman of faith. Little becomes much. And she left $150,000 to the University of Southern Mississippi. And she put it for colored kids who couldn't afford, colored students who wouldn't be able to afford to go to school. Right. And so she left money also for her church, as well as for her family. I encourage people to make sure you write the vision and make it plain, because if you are strategic, if you are thoughtful, if you have the right advisors, you can make your dreams come to life. Now, but legacy building is such a such a personal decision. Everybody gets to identify what is important to them, because what is important to you may not be what's important to me, but we get to create the strategy to achieve the goals that we want. Now, as Tony initially introduced me to say that I was the start of the Griffin firm, and I did, but then I realized it's not about me. When I first started my firm, I honestly wasn't sure what I was going to do, how I was going to do, how I was going to survive. And then it was the Griffin firm, and it's easy, that's my last name. However, but if it's about the purpose that we have, I don't want people to think that it's about me, but it's about the service that we provide, that we support people to build, their life, the legacy, and how do we strategically plan for that? And so we changed our name and we're doing the rebranding, which is not an easy task, right? The bottom left corner is a picture of my children, my biological children, and my son's daughters. Now, both of my children are married. And so, but I will say to you, what's important to me is my biological chain, my children and my children's children. So I am thoughtful about creating a legacy that protects them. I am a member of Kingdom Fellowship AME Church, and I'm a tither. And as such, I expect that when I pass away, that I will be able to continue to tithe, because I believe that when you have income, you make sure you make that distribution. So you can plan for that, but you can only plan for that if you plan for it, right? It's not going to happen by happenstance. And I also created the Association of Black Estate Planning Professionals, because I believe that as an estate planning attorney, I can't do anything without financial advisors, insurance people, CPAs. There's a family office that people with high net worth create. And so I think we have the rights, the responsibility, the opportunity as Black people to have that as well. And so I'm mindful about creating that collective so that we can bridge the racial wealth gap. But again, that nonprofit is one of the things that I'm doing for my legacy. So I encourage us all to be very thoughtful about creating the path that we want to have to move forward. Now, there's a pyramid for everything. There's a food pyramid. There is a self-actualization pyramid. There's an Amway pyramid. And so there's also a family legacy pyramid. And the bottom rung, the most foundational things that we can do is, am I okay? Do I have my stuff planned if I am sick? Am I planned for my future? Do I have that stuff in place? The second part of it is the next level. Just a second.
Please mute if if you got some background noise, if you don't mind, thank you.
Okay, so the second level is my family, okay? And again, I don't limit the definition of family to biological or legal relationships. My family are those people that I care about and love, right? And so I encourage people to make sure you're planning for your grandchildren, your nieces, your nephews, whoever that chooses to be. When I say grandchildren, nieces, and nephews, not the biological children solely. It is the spiritual children, community children, children's children of your friends. But whatever it is, those people that you're invested in, those are the people that we think about. And then, but the pinnacle of the pyramid is my community okay? Do I have my charitable distributions? Do I have my civic religious groups covered? Now I say, because only 30% of Black people have an estate plan, if we just inverted the statistic to 70%, I don't think our HBCUs, our organizations and institutions would want for anything. Our Divine Nine would have enough to not have to plan or to struggle, but only if we took the efforts, took the initiative to all plan accordingly. Now, again, it is multi-generational wealth building. That's what leads to wealth. And we're just planning for the week. We're planning for to each paycheck. We're not going to make money for our generations. We say all the time is that we're building strong communities, one family at a time. We can't do that if we're just focused on that next week. Wealth building is the long game, right? We have to look at 3 generations. Now, the foundational documents that everybody should have at the age of 18, right? 18 is when we become legally an adult, and we never know what's going to happen. We never know what day. And so if we have it, if we're ready, we don't have to get ready, as so many people say, but let's plan for it. But the 3-legged stool of foundational documents, first and foremost, is the power of attorney. That gives somebody capacity to act on your behalf for financial matters. I encourage people to be thinking about not just it should be, don't just do the cookie cutter approach. What we know is I'm a professional pessimist, so I know that, and I say that oftentimes we need to be thinking about the 2 G's, greed and grief, and planning accordingly. Now, we should be thinking about that who can manage my finances if I'm unable to, but we should have a backup to that person, and sometimes a backup to that backup, because we don't really know who's going to be able, who's going to be ready. The second leg of that stool is the healthcare packet, and we believe there should be 4 parts to it. First and foremost being who's going to make decisions for you regarding your healthcare when you're unable to. Second thing being the advanced directive living will tells them what to say. Now, while they're the person who's selected to make the statement, it should be based on what your desires are. And then thirdly, there's the HIPAA waiver. Can't make any decisions for you, but they can be informed. They can talk to your healthcare providers. They can look at your medical records. And that can go on for 2 years post your death. And then the end of life celebration. What does that look like? Would you like cremation? Would you like traditional burial? I had a mom call me and say she wanted to sue her son-in-law because her son-in-law burned up her baby, she said. And it was that the son-in-law had chosen cremation. And so, but she was grieving. And I say greed and grief are those 2 G's that we need to guard against accordingly. And then the last will and testament. The greatest thing about the last will and testament for people with minor children, it helps identify who the guardians would be, but who the guardians would be in case something would happen to you. Now, the last will and testament is, I think TV does a whole lot of scamming. They do the reading of the will on TV, which creates the illusion that's all you need to do is have a lawyer or some other professional read it to you. And then you have the capacity to go and distribute the assets accordingly. But know this, that while each jurisdiction is slightly different, that the court is, the will directs the court probate process. You have to take the will to the court and the judge signs an order, and therefore you're able to do what is said after the judge signs the order. So I encourage people to know that, again, it's just good TV to have the reading of the will, unless, of course, you're afraid to tell somebody what it says. And that happens regularly as well. But so who will handle your finances when you're not able to? right? That durable power of attorney, who do you want that agent to be? Just because Pookie is your oldest child doesn't mean that Pookie should be the one who's appointed. If Pookie or Susie or Frankie hasn't balanced his or her checkbook, don't let them start with yours. If they often need a little extra something to get through get through to the end of the month, that's not the person, right? Know who you need, know who you want, know what their integrity is, know what their financial capacity is, and therefore make a decision. But of course, make a backup to that person, right? I always identify the fact that, again, I mentioned I have 2 children. And if my son was going to be my power of attorney and taking care of my finances and decides that, okay, in order to take me around to help me have a better life or to take care of me, he needs to get a new car for me with my money, and he gets me a Tesla. That make my daughter a bit concerned because that's their inheritance that is being used up. So I encourage people to be thinking about who is that person. And many times we put checks and balances and parameters around what that looks like, but they're not going to stop having your mortgage to be paid just because you're no longer there. Now, the advanced directive living will. Who will make decisions for you when you can't make them for yourself? John Pierre Adams was a professional soccer player, and then he was getting a knee replacement surgery. And what happened was there was malpractice. And unfortunately, he ended up in a coma. He was in a coma for 39 years before he passed away. Terry Shiva was in Florida in her 20s, and she was in a car accident and was in a persistent vegetative state. Her husband said Terry wouldn't have wanted to live this way and wanted to allow her to die naturally by not providing nutrition and hydration. Her mom said she would rather live anyway than not live at all. And so they were in court for 15 years when the judge sided with the husband and allowed Terry to die naturally. Now, what I know is that the husband and the mother were at odds. They weren't able to grieve together. They weren't even able to support one another. But the problem is no one knew what Terry wanted. And so I encourage you to not put your loved ones in that position. Now, for the last will and testament for probate, right? The last will and testament, as I said earlier, directs the probate process. As such, it has to go through the proceedings. Now, again, you guys were in multiple states, so I'm just going to do an overall what happens when. When someone passes away, the person who is identified as the executor, because they're not an executor right away, goes to the court. When they go to the court, they give the court the will, if there is one. If there isn't one, there's a slightly different rules. We'll talk about that secondarily. But if there is a will, they give it to the court. And they also have a petition that the court requests, right? And the petition identifies the amount of assets that are in this estate. The more assets that are in the estate, the more you pay the court for court fees. So I encourage people to think about the fact that you're paying the court to give your stuff away. Then the first thing that happens is, or the next thing that happens is, they put a notice in the paper that said, Aimee died, does she owe you any money? Now, then they give you a time frame with which to come forward to say that I owe money. Then you have to set the executor, who is appointed, will have to satisfy all those claims. If Sears and Roebuck, American Express, Amazon, student loans, or hospital bills were presented when I passed away, then they have to be satisfied before any distributions are made to my loved ones. I encourage you to be thoughtful about how do we protect those assets? How do we avoid probate? Because I don't necessarily want that to happen. But another thing that happens is life insurance. Now, there are a couple of things I encourage people to think about with life insurance. Is many times we identify life insurance as, I'm sure not the people with your group, because we know that life insurance should be a significant asset so that it becomes to help build legacies. But for those people, there are many times people expect that the life insurance is used for paying for the funeral. And so if you we had a circumstance where there was a father who put his life insurance, put his half for his daughter and half for his son. When the funeral came and went, the son said, well, the daughter paid for it all and said, I can collect from from you, my brother. My brother said, nah, the life insurance, I'm the beneficiary, so it is mine. I don't have to pay for anything with that. And it's been about 4 years now that we've been in litigation over that matter. The second part about that is life insurance is, if you receive a big check for life insurance, it's often perceived as like a lottery winnings. And what we know is lottery winners are 4 times more apt to file bankruptcy than a typical person. So if you think about, if we're giving someone a wide, a significant big check all at once, and they're not used to having that level of financial assets, do we know that that's going to be managed appropriately? If you're giving it to an 18-year-old child or even a 21-year-old child, what happens for that? The court, if you have a child again who is their parent passes away and they could potentially receive assets, the court's not going to give it to anybody who's under 18. There's a Uniform Transfer to Minors Act, which would require the creation of a guardianship and a trust, and that the court monitors. So I encourage you to be thinking about, how do I really protect the assets for my loved ones, and sometimes protect my loved ones from making decisions that are foolish. Now, I said that if you have a will, the chances are great that you get to have it based on what you want. Sometimes you do, and more often than not, you do. More often than not, that the court will allow your probate distributions to stand. There are some cases when it won't. For example, if you have excluded your spouse, the only state that allows you to disinherit your spouse is Georgia. Every other state has a choice for you to take a spouse to create what is an elective share. That elective share means that if, my husband died, he left me $150,000, and I would have been able to receive $250,000 if there was no will at all. I can select the elective share. And so that would really override the will. So I encourage people to think about that. Now, many times people believe mistakenly that if I die, everything goes to my spouse. That is not true. And many states are slightly different. And it is that a spouse receives a portion of the estate, and your children or your parents can receive the balance. Again, each state has a different law of intestacy, which is the rules that govern the distribution of your assets when you have passed away. But again, more often than not, your spouse shares it with your loved ones. And so I had a case where the husband was the only named on the house. And so when he passed away, his wife would have received half the house, and then his son would have received the other half. Now, that's really challenging to get a half of a house. And so the expectation is that the house would be sold in order for it to be, in order for the distribution to go forth. So I encourage people to be thoughtful about what is it that you want to achieve, and we can create a plan that doesn't leave your loved ones, in this case, homeless. The mom would have been homeless. I encourage people to avoid probate, and there are typically ways to do it. There are a number of ways to do it, one of which is putting beneficiaries on all of your assets. Now, that avoids probate. That isn't necessarily the best thing to do, but it avoids probate. And for real property, you can do a transfer on death deed in some jurisdictions and life estate deeds in others. So it all depends on where you are. But I encourage people, especially, to protect your real property, because if you, for example, have real property that goes through probate and you don't have a lot of liquid assets, what would be required to satisfy any debt would be the liquidation of your real property. But if your real property doesn't go through probate, it doesn't create that opportunity for someone to put a demand on it. Now, if you don't have a power of attorney or a healthcare proxy, and you cannot make decisions for yourself, then again, the court is involved and they identify a guardianship. They commence guardianship proceedings. If you're in the hospital and you can't make decisions for yourself, the hospital will commence guardianship action. And the guardianship, again, is one of those things where there's a court involved, and when there's court involved, that means lawyers involved. In a guardianship capacity, there are 3 lawyers. There's a guardian, there's a lawyer for the petitioner, the person who's identifying the fact that there's a disabled person. There's a lawyer for the disabled person, and then there is a neutral. And so the payment is often coming from the person who's disabled. So I encourage you to be avoiding that, because if you have a power of attorney in place, you don't need to have a guardian. That's a significant decision, right? That we can avoid that, because if you don't select someone on your own, if you don't have a power of attorney, if somebody is appointed guardian who is not your loved one, then you have a neutral who's appointed, and that person is paid typically hourly, and that can be a significant financial decision. If you have a loved one who is serving as the guardian, and they often, most typically don't charge, but the other part is they have to get a bond. No matter who it is, they have to get a bond that represents the value of your assets annually. So it could equal the value of your assets, the real property, all of those things, depending upon what the court decides. And so, and then there is a required criminal background check. If the person who you would like to serve does not, can't pass a background check, meaning that they haven't committed a felony, then they can't serve. And then once again, that person who is appointed it charges hourly. There is a movie on Netflix called I Care a Lot, and it speaks to that vulture situation which is not typical. Lawyers who are appointed aren't typically trying to take from the disabled person, but the reality is lawyers are paid for their time. And so if, for example, in the district, if you're going to go to the bank to open a bank account for the person who's disabled, it takes you about an hour to get there, no matter where you're coming from or going to. The second thing is you're spending at least an hour in the bank to open that account, and thirdly, the hour to get back. If you're charging $500 an hour, that's $1,500 that is being charged just to open a bank account. So, and what you know is that guardians are required to visit monthly, that there are meetings and plans, and all of those, each of those moments are paid for. So I encourage people to be thinking about, how do we avoid that? Now, we talked about the foundation documents, and that is the power of attorney, the healthcare proxy, and the last will and testament. If you're going to move beyond the foundation, what I recommend for everybody with a minor child is having a standby guardianship designation. Now, I was in court yesterday with Monday with a young man who we're looking for a guardian for, because both of his parents died in a car accident in May 2022. And we end up getting an expedited hearing this month because he needs to have surgery next month. So I encourage people to have a standby guardianship designation to appoint someone who's going to act, so that they can have the legal authority to act on behalf of their minor child until they can get to the court proceeding. Now, then the trust, a living trust, is a trust that's created during your lifetime. And there are 2 categories of trust. The greatest thing about trust, or the greatest things about trust, is first and foremost, it's private as opposed to public. A last will and testament that it goes through the court process is a public document, a public process. And anybody anywhere can choose often just to go to the courthouse or download the document from the courthouse docket and see the last will and testament. And you will see that there are vultures who just sit and watch to see the assets, and then they would go to the house and connect with the interested persons, being the executor, to see if what they can get. So I encourage people to avoid probate in that manner, because again, the trusts are private. The second thing about the trust is, of course, they avoid probate in total. But you get to create rules. I say that the trust is a rule book. You get to establish who gets what, where, when, and how. It can be that they have to go to college. It can be that they have to get a house. It can be that they need to get a prenup. Any of those things that you can put in place, because it's a matter of, it's a gift of yours, your assets to them, and they don't have to receive it. So they don't have to go to college, but they don't have to get that money. They don't have to get a prenup, but then they don't have to get the money that you identify. We get to put the rules. Again, for example, one of the rules that I put in place is that my grandchildren cannot use my money for any depreciating asset. They can buy depreciating assets with their stuff, but not with mine. So the revocable living trust is an extension of you, uses your social security number as an identifier. Again, it's a rule book. It identifies everything you want, but it maintains privacy, but you also get to maintain complete control. We often call revocable trust as the legacy building trust because you get to create the rules for multi-generational wealth building, right? The irrevocable living trust is more like a corporation. If you think of the revocable living trust like a DBA, right? The irrevocable trust has an EIN, and you relinquish some of the control. And with that in mind, it's not included in your estate. And why that's important is because for depending on where you live, there is an estate tax. An estate tax is the tax that is applied to the assets that exceed the estate tax exemption level. In the District of Columbia, $4 million is the estate tax exemption limit. That means all of your assets that are in your name, as well as your life insurance policies, your retirement benefits, your real property, all of those things are added together to be a part of your estate. And if it exceeds the estate tax exemption level, then it is taxed, everything above that. Now, in DC, I mentioned that it was $4 million. In Maryland, it's 5. But the key is there's also a federal estate tax exemption. Right now, it's 12.94 million. But the expectation is that in 2025, it drops down to about 5 or 6 million. And so we encourage people to be thoughtful and planful about that. If we have assets that exceed the estate tax exemption level, then we put that in the irrevocable trust, right? Because it doesn't count as yours. When I said there are 2 categories of trust, I'm very mindful of that. We use an irrevocable living trust for a special needs trust. We use an irrevocable living trust for a family foundation. We use an irrevocable living trust for a life insurance trust. And so the question is, it always depends because we strategically plan appropriately for what is the goal and the achievement that you're trying to make happen. And then the strategic business planning, just like as a person, you need to have a plan for an estate plan. You need to have an estate plan for your business as well. Right. Now, I always spend a little time on real property because, especially in the Black community, real property is one of the great legacy builders. And it is typically 67% of our net worth. Right. And it can be used for legacy building. And one of the things that I know is that in the Black community, we are losing land based on what we used to have. The amount of land that we owned as a people is diminishing. So I encourage people to be thoughtful of how we protect it because property appreciates, money evaporates. So when I think about legacy building, having 1 house to leave as an inheritance and 3 children, leaving a third of a house is a problem because that typically requires the sale of the property in order for someone to get their fair share. Again, we only need 1 person or actually 1 person's spouse to contend that there is a need for those assets. So I encourage people to be thinking about how do we protect that. And so many times we put them into a trust and can make decisions accordingly and then preserve them so it doesn't have to be partitioned. Capital gains is when I encourage people to not put their children's name on their houses with them. And that's in like 95% of the cases. 5% of the time, I would say, put your kid's name on your deed with you because we're protecting against Medicaid long-term care planning if your loved one needs to go into a long-term care facility. And we're not going to talk about that today. But joint tenancy with right of survivorship, I call that the last man standing law. And that's cool. Like with your spouse leaving my husband and I are on deed together. And then the last one who dies is the one who owns it. Because if you die, the other person gets it, the last man standing law. That's cool unless there's a blended family. And then the person who is dies first, their heirs tend to be overlooked. And so I encourage people to think and plan accordingly. And then in many cases, there are reverse mortgages. A reverse mortgage is when you take the equity out of your property and you don't pay it back, and it's for seniors, you don't pay it back, and interest continues to accrue. Upon that accrual, I mean, you don't have to pay it back until the person passes away or moves out of the property. That is fine if indeed you don't really want to pass that property out on as a legacy builder. But if you do, I encourage people to pay the interest down so that it creates a capacity for at least the refinancing to preserve that property. And then charitable giving, being mindful about, sometimes we donate appreciating assets so that we can get this to avoid that capital gains tax, right? So I encourage people that when we're doing all of these things, that we are mindful of the tax planning. If you are in a state that has an inheritance tax, we need to think and build and plan accordingly about how do we want to make sure that we can make sure that we don't lose our assets because the person cannot manage the taxes, right? And so heir property is a significant issue because many times we don't probate as we go along when people have passed away. And so I encourage people to be thinking about, if your great grandma had property and then she had 4 kids who had 4 kids, who had 4 kids, and nobody probated it, they just moved into the house and it still was in great grandma's name. You have 48 people who own. Unfortunately, you can't do anything without all of the owners agreeing. And so many times that ends up in tax sale, because if you can't maintain a property, it becomes uninhabitable. So I encourage people to be thinking about, how do we protect our assets by when there are multiple assets, or when you want to have heir property or family land, then you create a trust and then can protect it accordingly. Now, 2 ways to look at estate planning. One is divide and disseminate. It's say we have 3 children and $900,000 to distribute. That we can say each kid gets $300,000, right? However, that's the divide and disseminate approach. The create and collaborate is create an enterprise and then having the 3 children work together to build an enterprise so that they can leverage that $900,000 as opposed to the diminution of having the $300,000 each. So I encourage people to be thoughtful about, how do we strategically build and plan for the next generation and that next generation. And then business owners, what we know is that we need to plan accordingly for our businesses as well as our personal property. And many times I would say that, as Stephen Covey says, begin with the end in mind. Many have folks say, okay, I'm just starting. It doesn't take much to start a business. You can be a sole practitioner and use your social security number as an identifier. And as a result, when you pass away, your business is gone too. If you have 2 sole practitioners coming together, a partnership, one passed away, again, that's the end of it. So I encourage people to know what is the appropriate planning to what you want. And I think that oftentimes we start businesses because we need a job, but we need to think beyond that. We need to think bigger and greater and know what we want for that long term so that we can strategically plan what we want. So I always talk about succession planning and the 5 Ds of succession planning: disability, divorce, departure, dissolution, and death. All of that should be a part of the strategic succession plan, because what we know is if we don't plan, anything's going to happen. It'll be the default. And unfortunately, many businesses have just everything that you've worked for is lost as a result. That's indeed how I initially got into estate planning, because I was working, I had started a Black Chamber of Commerce, and I was working with a business owner, and he passed away, didn't have anything in place, and it was as if it was a fire sale. So I encourage people, don't let that happen. If you're building an enterprise, building anything, the people that you work with, work for, as contractors, we don't want to just let it all go up in smoke because we haven't had a plan. So I spoke quickly. I tried to go fast because I figured I wanted to leave as much time for questions as possible. Okay, was this helpful? Was this enlightening? Did you learn anything new?
Yes, this was very helpful.
Thank you for that.
Ma'am, I have a question.
Great.
If you don't mind, are you ready to answer questions or
I'm
am
ready
I?
for questions. You're right there.
Okay, so you touched on a lot of things that I'm kind of dealing with now. So I have two elderly parents. One of my parents, I am her power of attorney. I'm not my dad's power of attorney. The situation with my mom is my mom has dementia and she has property. So I'm trying, and you talked about probate, and I'm trying to figure out a way to avoid private probate. So of course, I'm in the state of Mississippi, and I'm her power of attorney. So when I had an attorney look at her power of attorney, I wanted to set up a trust, because I want to avoid the probate, but they told me that it didn't specifically specify that I could set up a trust. But the power of attorney does say I can make financial decisions on her behalf. So what is your recommendation of how I can leverage and try to protect her property, and to make sure we don't have to go through probate in the event that something happens to her? Well, in the event when something does happen to her, because I could go first.
Exactly. So yes, one of the it's so often that people have insufficient powers of attorney, right? That is unfortunately very real. And so what the question is so what's the alternative, right? If you can't provide a trust, and then the answer is still, it depends on what the authority that what authorities are given. Does it give capacity to transfer property, right? That sort of thing. Now you can't give stuff away typically, but you can find a way to strategically gift if there's gifting powers, right? So can you gift it to her husband? You know, those are the kinds of questions that we have to think about, to know what you can't do because it's not in there, but what can you do based on the rules and restrictions of the power of attorney that you have. And so that's, one of the problems with, sometimes people just download the statutory form or download a form from
No, in my case, I actually saw a lawyer, paid a lawyer.
Did you pay? Was it an estate planning lawyer or was it a generic lawyer?
I gotta go find out what her practice is.
That's
but
it. And see, that's so again. So I mean, and that's water under the bridge on one level, but it is find out have someone look at the power of attorney with you, identifying what powers are included, and then with that create the strategy.
Okay, but you
can transfer those.
But you talked about transfer of the deed of transfer on death. You talked about that, and I had been looking at that too.
Yeah.
What I wanted to ask you was, I noticed like on some of those deeds, it talks about an executor. Who exactly can serve as an executor?
So the executor is the person who is appointed after the death, going through the probate process, right? That's the problem, right? One of the things that, that's a problem. It doesn't come to effect until after someone has passed away and appointed through the probate court.
Okay, so the transfer of death deed is still have to go through probate. That's what you're telling me.
No. The transfer on death deed does not have to go through probate.
That's what I'm talking about. I noticed I saw one for the state of Mississippi, and it said something about you have your notary public, and then you still have an executor. That's what I was asking. Who can serve as executor? I think I saw something along those lines.
So if you're, this goes back to your power of attorney. If your power of attorney allows the disposition of real property.
Okay.
Right. And that's what I was saying. It depends on the powers, because there are some that do and there's some that don't. If you have the authority to manage the real property, then you can do that. Then the last effort is another effort is to become guardian.
Okay.
And as guardian, you could create a trust as well.
But as a guardian, then we still have to go through the courts to
you do go through the court, but it's a different. But there are two things. Yes, you have to go through the court, but you'd be the guardian on one level, and then you can avoid the probate, and you can protect the assets.
Okay, thank you.
You're welcome.
Oh, one more question. you did talk about deeds. Like you talked about if there's I guess a parent to avoid or protect the assets, putting the child's name on the deed.
So yeah, so in Medicaid situations, right?
Mhm.
And you can create it such that you can do a joint tenancy with right of survivorship, because Medicaid has a 5-year look back period for assets, with the exception of 2 years for real property when your child has lived with you.
I give it to you.
We did it.
Yeah, you handed it to you. You had it on.
So when with the exception of the 2-year exception, when your child has lived with you to protect you from going into a facility, then that
Right.
is the exception.
So you said so how far in advance you'd have to do that in order to keep them going back and doing the look period? Is that 2 years or 5 years?
For real property, 2. That's the exemption.
Okay. So in other words, if you were about to go and, Medicare needed your property to make sure that you could be taken care of in a facility, you would have had to already done your name being put on the wheel.
Before they go into the facility, you need to be on the deed with them.
Okay.
Yeah.
Thank you.
You're welcome.
All right. I don't know if Sandra, if you had some questions. I know you were unmuted there for a second. If so, please unmute and ask. Anyone else have any questions? Just unmute yourself or hit the raise your hand. Here's a great time to ask some questions. Yeah, I think it interesting, Amy, that we talk about Aretha Franklin and not having gotten the proper, estate planning professionals in light of what happened with her dad. Her dad was shot twice and was in a coma for the great Reverend C.L. Franklin was in a coma for 5 years. Yeah. And, in light of that, you would have thought that maybe she would have, had those things in place, but we know how that goes sometimes.
Well,
so.
I mean, especially since, again, it's not like she planned an elaborate funeral.
Right.
She planned this elaborate funeral, but did not plan. I think I guess she thought she knew.
Mm-hmm. Let's see, we got one question in the chat from Noreen. Difference in trust revocable versus non-statutory irrevocable complex trust. I think you talked a little bit about the revocable and irrevocable.
Right. So the revocable trust is a trust that is an extension of you. And we talk about those as legacy builders. And a simple trust distributes all of the income annually. All the income of the trust is distributed annually. A complex trust is one that, and that's oftentimes what we use to create multi-generational wealth, so that it doesn't just stay the same. We want the principal to grow so that we don't distribute all of the assets or the income, and it goes back into the trust for growth. So that's the complex trust. Now, when you are living, your revocable trust is an extension of you, used as your social security number. When you pass away, your social security number is no longer available to be used. And so you're no longer able to change your mind, right? And so it becomes irrevocable upon your death.
Now, when that happens, and it becomes irrevocable, is it issue an EIN number at that point?
And yes.
Okay. Because I know that's one of the things is with the revocable, there's no EIN number. It's not a own legal entity like it is with the irrevocable. And I was glad to hear you say that you kind of utilize both of them depending on the asset and what you want to happen with that asset.
We have many people who have both.
Yeah. Let's see, any other questions out there? I know one of the things that did come up was the how do you, or where do you see foundations? I remember you saying that irrevocable is a place to maybe create or house a foundation if someone wants to create a foundation, or maybe even, I guess a foundation could be nonprofit. It doesn't always be that way. So can you talk a little bit, just briefly, about that?
So we do a lot of foundations that are thoughtful about, they want to make giving as a part of their legacy. And so there are times when we just are teaching our children, or just building the structure accordingly. And so it is typically a nonprofit organization, entity, and it is based on the values that you have. And so we typically, for the people who give, we typically, oftentimes our family members are the employees of that nonprofit family foundation. And what you know is the rules for the family foundation is you have to give at least 5% of the assets annually, just 5%. And so, but it's a tax deductible or tax exempt organization.
Okay. And so making contributions into the foundation, and I know we have Timothy and Valerie who are tax professionals, is going to be a deductible charitable gift.
Exactly.
And does it play a part in how that foundation, who benefits from that foundation?
So again, it's not, you can't say, okay, I am just, it's for God bless us for no more. It has to have a charitable purpose, right? And again, it does indeed go, you do those filings. It is a matter of, but the difference is that we're not looking for public charity. It's just the assets that private assets that are going into the trust for distribution.
And then another thing that I noted is we're talking, and I wanted to make a point of, is sometimes when we have those nursing home situations and the nursing home becomes the guardian.
That's right. And so the nursing home, well, if they don't feel like they're getting paid in the way that they want to be paid, or that the person isn't able, they will pursue guardianship in a minute. And so we encourage people that, make sure we have this stuff straight first. Make sure that you're paying attention, because they will slide in that guardianship motion without even telling the family members.
Got it. Now, the other thing I wanted to mention, as we were talking about estate and estate taxes and exemption, I did want to point this out to people where, you mentioned 67% of our wealth is in real property. Well, much of our wealth oftentimes are in tax qualified plans, 401ks, these type of things, TSP accounts. And those things are going to be taxed as ordinary income, regardless of the state. They're going to be taxed outside of the state, although they go into the calculation of whether or not your estate's going to be taxed. Just like life insurance proceeds aren't taxed themselves, but they do go into the calculation to determine whether or not your estate is going to be taxed and what that tax rate is going to be.
Exactly. So that's why we often create irrevocable life insurance trusts, right? So that are separated from your estate.
Yeah, ILIT and those type of things. So makes sense. We had another question in there for let's see. Thank you for amazing information. What would be the best way to get started with estate planning?
The best way to get started with estate planning is, one, contact a qualified estate planning. Don't go to a real estate. Don't go to one of the things I always encourage people to look at, if it's a solo practitioner and they have 72 different kind of practice areas, that's not the one, right? And so identify someone who is either, clearly focuses on estate planning, because it's the nuances of estate planning that's really important. It's so often that the devil's in the details so often, but we've got to strategically know what you're talking about. And one of the reasons why I created the Association of Black Estate Planning Professionals is I want to make sure that I refer to people who are specifically focused on estate planning, so that we can create that multi-generational wealth. So you could, if you don't have someone in your area that reach out to me. I pretty much probably will know someone or can find someone. And so you can reach out to me. Tony has my contact information, and he can share that. Our URL, when we're being cool, is yourestateplanningattorney.com.
Awesome. And I know you, wonderful organization. And you know, I think I've done a couple panels and stuff for you guys, and it's always top-notch people that we meet when we are doing that. So, and as far as your firm itself, Amy, are there any states or I don't know if it's better to state states that you don't operate in or states that you do. So if someone wanted specifically to work with your firm, what does that look like in terms of geographically?
So geographically, it's so funny because in 2 months it will change, but I'm not going to let that out quite yet. But so that's why I say just check us out. Send me an email through the website at yourestateplanningattorney.com. And if you are, because I'm not going to say it publicly, but if you reach out to me, I can slide in some information, right? Depending on where you.
An announcement is coming, so I'm
excited, but I'm until
as a good attorney, not saying too much, right?
Until the ink is wet. Until the ink is wet, we're not.
I understand. Anyone else? Anyone else have any questions? Thoughts? Noreen, and I know that you are taking care of your husband from the accident, but if there's anyone else that has any questions, here's our time. Otherwise, we will bid you all good night. And again, Amy, thank you so much. You always deliver such great information. And so we appreciate that for sure.
Tony,
Service.
I'm sorry, I have one quick question and I have a comment. If you would, could you drop the URL in the chat? I think I tried to put it, but I didn't get it. And second, Attorney Griffin, thank you for your presentation and for your patience and for answering my questions. I would say you kind of shocked me starting out your presentation. Seemed like you kept hitting home here in Mississippi with your references. You pulled Steve McNair, and Steve McNair went to Alcorn, so I know him well. And then of course when Miss Osceola, I remember when she was saving the money and USM got all the money, not a HBCU, but they got the money. But I understand why. But yeah, I said, well, she's doing her homework. She's hitting home right here in Mississippi.
I thought the same thing. I thought about with Steve McNair being at Alcorn State, and yeah, absolutely. So excellent. All right. Someone asked, do you offer consultation?
We do, but you have to reference that it was that you were from Tony. You have to reference Tony in order to get a free consultation.
Reference the Real Money Coach. We bring you value. There you go. So, all right. Well, thank you all. I did record this, so you may see parts of it. I may slice it up and put a little bit of information out there, bits and pieces. We may actually post it in our private Facebook. If not, make sure you do this. Make sure that you subscribe to the Real Money Coach on YouTube, because that's probably where I will house it. And if you subscribe to the Real Money Coach on YouTube, you will get notification when I do post the video. So with that, everyone, just want to wish you all a great evening. Amy, thank you once again for taking time out of your evening to share this information. It was really good. It was really good, very educational. And I was proud. I was like, I got some things right in chapter 6, right? I got some things right in chapter 6 of my book. And so thank you all so much. If you guys need any information from me, I think most of you know how to get a hold of me. If not, you can work back through Noreen or find me Facebook, YouTube, website, The Real Money Coach, what have you. So thank you all, and everyone have a wonderful evening. Bye-bye.
You too. Good night.
Thank you.
Can I give you a motion?
Thank you.
Thank you. Thank you.
Thank you.